So you may be one step ahead of me on this already, but Commissioner Tate had lots and lots of questions about how the Gotcha rider impacts risk overall for the company, and would want to point out that Mr. McKenzie was our expert witness on that. He addresses it extensively beginning on page 30 of his rebuttal testimony, and he is here in the room today. And
If Mr. Tate wishes to ask,
yes, sir,
we'll ask Mr. Tate
we will. Okay, thank you.
before we move on, okay?
Sure.
You want to ask further questions?
I appreciate the offer. I don't think that's necessary at this time, though.
Okay, thank you. Thank you, Mr. Danjo. Thank you.
Thank you.
We're going to proceed then, Mr. Parks, or who's going to call a witness? Mr. Manis? Oh, excuse me, it's not y'all. It's the Attorney General. How dare me to forget that? Mr. Lewis, would you like to call a witness?
Yes, sir, I would. I'd like to call Greg Meyer.
Yes. I had too much diet green tea at lunch.
Mr. Meyer, can you please state your full name for the record?
Greg Meyer.
And where do you work?
I work for Brubaker and Associates.
Okay. And in that capacity for working for Brubaker and Associates, did you file direct surrebuttal and opposition testimony in this docket?
I did.
Do you have any edits to the testimony that you filed?
I do not.
I will tender the witness.
Thank you, sir. Any cross-examination?
Just a few questions, Your Honor.
You may proceed.
Good afternoon, Mr. Meyer.
Good afternoon.
Isn't it true that your testimony did not actually propose a revenue requirement in this case?
That's not true.
Where in your pre-filed testimony did you say the revenue requirement should be X?
We addressed it from a revenue deficiency perspective.
So not from a revenue requirement perspective.
The revenue deficiency is merely a component or an adder or subtractor from the revenue requirement. So my analysis, I disagree with your assertion that we did not look at a revenue requirement. We looked at the impacts from your proposed revenue deficiency with our adjustments, but those are revenue requirement adjustments.
Thank you, sir. But to be clear, my question was, did your testimony say the revenue requirement should be X?
No, my testimony said the revenue deficiency should be X, which is one step further than the revenue requirement.
And in that vein, let's look at page 4 of your opposition to settlement testimony. Table GRM-opposition-1.
Page 4?
Yes, sir.
Okay, I'm there.
Yeah. At line 3 in that table, you present your adjustment to the large sales non-demand usage as an adjustment to the revenue deficiency, correct? Line 3 of the table, sir.
Oh, okay. Yes.
Now, if we go to page 9 of your opposition testimony, lines 1 through 2, you state that your adjustment to the large sales non-demand class usage results in a, quote, reduction to the proposed settlement revenue requirement of $103,681, right?
Correct.
But that isn't actually a reduction to the revenue
You're
requirement, correct?
Correct. That should be saying revenue deficiency. Revenue requirements do not have any recognition of revenues. Revenue deficiencies take into account the current revenue streams to determine what the revenue deficiency is. The revenues should be consistent with what's included in the examination of the revenue requirement. But the term revenue requirement does not include any recognition of revenues.
So bottom line, a reduction to the revenue deficiency for this particular item has no impact on the revenue requirement, correct?
The revenue requirement is a set number. The amount to be collected in the revenue deficiency can take into account the revenues that were understated in the case.
Okay, but to back up real quick, page 9, lines 1 and 2, you did just correct your testimony that it shouldn't say revenue requirement, right?
That's correct.
Thank you.
Thank you. Staff, do you have a cross?
It's okay. I can bring my laptop up just in case. I don't think I'm gonna have
You know, if I was intended to hear that, I didn't. What'd you say?
Here's us.
Okay.
just clarifying. Could I bring my laptop? I did not print all the materials, but
That's
just
all
in case, I don't think I'm gonna need it, but just in case.
That's okay. Take your time.
All right, Mr. Myers, is your business address, is that in Chesterfield, Missouri,
Yes, it is.
or Missouri?
Either way,
Are you from Missouri?
I am.
And you say it Missouri?
I do.
Okay. I just asked. I had a friend in high school.
I'm
He's from
not-
Missouri.
I'm not
Turns
going to hold
into
it
a thing.
against you, neither one of you, but however you want to say it.
Okay. Anyway, that was my attempt at humor. In this matter, you're the AG's expert witness for race case matters. Is that correct?
Addressing the revenue deficiency, that's correct.
And do you also participate in other jurisdictions around the country
I
in
do.
this respect?
I do. Several.
And in your direct testimony, the total dollar value of the adjustments you proposed was higher than the adjustments you proposed in your opposition testimony. Is that correct?
The issues are decreased, and the dollars associated with those have changed as well. Yes. Some of the issues that I listed in my direct were resolved reasonably through the stipulation that you and the company entered into. So we didn't pursue those issues. The 4 issues we identified in my opposition testimony are the additional adjustments.
And I appreciate that, all of that, but is that a yes? That's your direct testimony, the total dollar value of your adjustments proposed was higher than your adjustments in the proposal in your opposition testimony. Is that correct?
That's correct, because the stipulation addressed many of those issues and resulted in what we believe, the AG believed, was just and reasonable rates for those issues.
Okay, I appreciate that. You're getting ahead of me a little bit, but that's okay. So you've dropped several of your adjustments from your direct testimony. Incentive compensation, was that one? Is that correct?
Yes, it was.
Because those were, as you said, resolved or partially resolved by the proposed settlement agreement.
The dollar impact from what the staff agreed to with the company for incentive compensation was at or near the proposed level of disallowances that we did. So the AG did not pursue that issue.
So again, your answer to that question is yes. You
I
dropped that.
gave you my answer. I don't know. I don't know what else you want.
In your opposition testimony, you've narrowed your contested revenue requirement issues to only 4 specific adjustments. Is that correct?
That's correct.
In your opposition testimony, only discussed aspects of the non-unanimous settlement agreement that the AG opposes. Is that correct?
My opposition testimony addresses the 4 issues that the AG office believes should be included in the revenue deficiency calculation.
Again, that's not the question I asked. Again, only the discussed aspects of the non-unanimous settlement agreement that the AG opposes. Is that correct?
Is in
That's
my
Is in
testimony?
your opposition testimony. That's only all you're discussing.
No, you have we have another witness, Mr. Dupree, who has issues with some of the.
Okay, you only spoke to. Anyway, I'm
not
going
trying to be
I'm going
difficult,
to
sir.
get to the 4 questions. Fine. No, that's fine. According to your table GRM1, opposition 1, those four remaining adjustments total to $1,948,247. Is that correct?
That's correct.
And in your opposition testimony, do you cite to or reference the settlement testimony filed by staff witness Jeff Hilton et al.? Do you recall?
I don't recall that I ever that I ever referenced Mr. Hilton. No.
In fact, your opposition testimony directly responds to certiorari rebuttal testimony of Black Hills witness Wendy Robbins. Is that correct?
Some of the issues refer to Ms. Robbins, correct?
And Ms. Robbins did not file settlement testimony in support of the settlement agreement, did she?
Nope.
Now, to the issues listed on the revised issue list filed on 8/18/2020. Now, I'm here from Little Rock, so I'm going to start at the end of the list. I want to talk about issues 7 and 8. Issue 7 being whether the settlement agreement establishes a reasonable level of straight time payroll based on staff's surrebuttal case.
I'm sorry, what document are you referring to?
That would be the revised issue list.
I don't have that with me. Okay. All right, thank you. All righty. I'm there.
Okay. So talking about issues number 7 and number 8.
Okay.
Number 7 being whether the settlement agreement establishes a reasonable level of straight time payroll based on staff's surrebuttal case. Is that
That's what it says, yes.
And issue number 8, whether the settlement agreement establishes a reasonable level of overtime payroll based on the staff's surrebuttal case. Is that also correct?
That's correct.
You're aware that staff agreed with the company in its surrebuttal testimony regarding these two issues. Is that also correct?
I'm not aware if they agreed in surrebuttal or not. I know that they agreed in the settlement, but I'm not sure if it was delineated in the staff surrebuttal.
Okay.
I'm not aware of that, but it doesn't change my position.
Okay. With regard to issue number 6, whether the usage per bill used to annualize usage for the large business sales non-demand rate class in the proposed settlement agreement is reasonable. Does that sound like issue number 6?
It sure does.
Is it fair to say that you and company witness Robbins disagree on how this is calculated?
What we disagree on is one customer class and the usage per customer class for that class. Yes, we disagree on that.
So it's fair to say that you guys you disagree on how this is calculated.
I disagree on the level of revenues for the large sales non-demand class. Yes. The settlement agreement understates that level of use.
That's not the question I asked. I just asked if you disagreed with the way it was calculated.
And I said yes.
Okay, thank you. Your rebuttal round of testimony indicated that Black Hills Energy Arkansas did not provide enough information for the AG to support its calculation. Is that correct?
So rebuttal page what?
Look at pages 5 to 8.
In there. I do.
Do you mind if I look at your copy?
Sure.
Looking at the sir rebuttal testimony of Greg R. Meyer. I'm pointing Mr. Meyer to lines 3 and 4 on page 8 of his sir rebuttal testimony. Are you with me?
I am.
Again, your sir rebuttal, I'm paraphrasing, but your sir rebuttal around testimony indicates that Black Hills did not provide enough information for the AG to support its calculation. Is that correct?
That's what that sentence says, but that's in reference to a claim back on page 6 where the circumstances of the fact that the customer usage, I'm sorry, it refers back to page 6, the Q&A on the first line or the first page where it says, does Mrs. Robinson's produce any actual documents or evidence to support her assertion of plant closures, plant consolidations, or plant energy efficiency measures? No, she did not. That's,
But again, is that you're saying there was
can I
not
finish,
enough
sir?
information?
Can I finish?
Sure.
That sentence there is supported by the question and answer online on page 6.
In her sir rebuttal round, the testimony company witness Robbins provided information, but you still didn't agree with the calculation. Is that accurate?
For this class,
Same calculation, but the sir rebuttal round.
just to make sure for this rate class.
Yes, for
Okay.
the issue we're talking about, issue number 6.
Okay, then yes, she did not. She made assertions about why the usage that she proposed was reasonable, and she listed these 3 conditions, but she gave no specific information, no specific customer information on why what had happened. And when I did,
So again, the answer to the question would be yes. You don't think that she provided enough information.
she didn't provide any information on plant closures, energy efficiency, or any of those 3 conditions. She provided nothing. So I guess that's yes.
With regard to revised issue list, issue number 5, whether unbilled revenue should be removed from the level of working capital included in the settlement agreement. Does that accurately state what issue number 5 states? That's
Sorry,
all the question.
I get back to the issue list. Okay. No, that's not it. Issue number 5.
Yeah, I'm just restating the issue.
That's, you stated the issue clearly from the paper here, yes.
Okay. And in your direct testimony on page 11, lines 8 through 13,
I got it. Page 11?
page 11, lines 8 through 13.
Sure.
In that section, you make reference to a main docket number. Is that correct?
I do.
Maine would not have any a docket in Maine wouldn't have any binding precedential value in Arkansas. Is it accurate to say that?
I would say that the information from Maine could be used by the commission to make a determination. So yes.
Could be used for persuasive purposes. Is that accurate?
Yes.
Also on page 11, lines 4, 14, and 15. You with me?
I am. I'm sorry.
Okay, I'm just going to give you an absolute quote there. Additionally, I'm not aware of any regulated utility in Missouri or Missouri that allows a return on unbilled revenues. Did I read that right?
Right, and that's a fact.
Your primary basis for this adjustment and opposition testimony is your disagreement with Black Hills witness Robbins' interpretation of Section 8, Appendix 8.1 of the Commission's Rules of Practice and Procedure. Is that correct?
Well, I think it's twofold. I don't understand why customers should be required to pay a return on unbilled revenue.
That's not what I asked. I just asked.
I was trying to get, the second part will get to your
Okay.
answer. So let me start again. The first argument is the practical consequences of putting unbilled revenues in the working capital allowance is you're requiring customers to pay a return on an aspect of that is not in any cost of service or revenue requirement components. Second of all, as I stated in my rebuttal testimony, Ms. Robbins, has not addressed the condition in Arkansas that it has to be necessary for the provision of service. Unbilled revenues don't have to be necessary for the provision of service.
Okay. Is it fair to say that you guys disagree on the interpretation of that rule part?
I don't know because Ms. Robbins, never replied to my argument.
And you disagreed with this her interpretation from your direct testimony. Is that correct?
Her testimony merely referenced that it's been in place since 1984. And all I'm saying is it still doesn't, the practical consequences of what you're asking for requires ratepayers to pay for an asset that isn't used.
Again, you disagree with the interpretation. Is that accurate?
I don't know what her interpretation is of the section you did because she never addressed it.
To your knowledge, was a motion to clarify this interpretation difference filed in this docket?
Not to my knowledge. And I don't think I needed it.
To your knowledge, was a motion to brief this issue based on the difference in interpretation filed?
To brief it? I think we have the issue in front of us today.
I'm just asking, to your knowledge, was a motion to brief that particular interpretation?
Oh, no.
Mr. Meyer, would you agree that a non-unanimous settlement is presented to this commission as an integrated negotiated package? Would you agree with that statement? Is that correct?
Yes.
And by opposing the settlement, you realize you put all the negotiated terms, including the acceptance of staff surrebuttal cost of service study, the company's proposed declining block rates, the customer charges for the residential and small business classes, and the ROE and equity ratio back on the table.
Well, I would recognize that the AG made that decision to do this moving forward with that knowledge, but I'm hopeful that the commission will just make these discrete adjustments that we proposed.
So is your answer yes? You realize that all
With the
this
caveats I gave,
potentially puts all of those issues back on the table.
it could, but it's been my experience that that's a rarity.
Thank you, Chairman. That's all.
Thanks.
That's all the questions.
Parks. Redirect?
Yes, sir, real quick. I want to follow up on that last question Mr. Parks just asked. I'm paraphrasing it here, but he said, essentially, are you aware that you're putting all these issues possibly back on the table? Do you believe that those issues could be back on the table from their inability to accept your recommendations?
I'm sorry, could you repeat that?
They made a question to you about your challenge to the settlement could put all these other issues back on the table, correct?
Correct.
Well, could it not be said that those were put back on the table by staff and Black Hill's inability to accept your recommendations?
That would be a possibility.
Okay. No further questions.
Mr. Parks?
I've just grabbed my laptop. Sorry, Chairman.
You hate to leave your brain out there somewhere.
I didn't look.
Ms. Anderson, do you have questions?
No, thank you, Chairman.
Mr. Tate?
Thank you, Chairman. Afternoon, Mr. Meyer.
Afternoon.
Are you familiar with the modified balance sheet approach that we use here in Arkansas?
I am.
So I'm not sure, does Maine or Missouri use the modified balance sheet approach?
Missouri does not.
Does Maine, or do you know?
No, they don't either.
I think it was Mr. Hilton's testimony earlier, and I hope I'm not misquoting him, that typically unbilled revenue is included as a working capital asset under the modified balance sheet approach. Do you disagree with that?
Well, I've understood that it has been since 1984, but when you
Okay.
look at the conditions of the modified business,
I understand the point you're making. I'm just,
the other ideas, the
Fair
other
enough.
things that are in the table, we agree with, and those should be in there. It's just don't require ratepayers to pay a return on unbilled revenues.
but if I understood Mr. Hilton's testimony correctly, traditionally that has been included in Arkansas.
Right, and I
Your
guess,
position is that it shouldn't be.
and I'm asking the commission to reconsider its past precedent.
Okay. So I think there was testimony by, I think it was Mr. Daniels earlier, that the reason you have a different level of straight time payroll is because you did not include the adjustments for the pro forma year. Is that accurate?
No,
Okay, so maybe I need an explanation then as to how you arrived at a different number than Black Hills did on straight time payroll.
so I took the 2025 level of payroll and increased it. I want to make sure I give you these percentages correctly. By 4.011% in 2025. That increase went into effect in March of 2025. So to restate, to reflect that increased level of payroll for 2025, I had to increase the January and February levels of payroll. Then you had a full year of reflecting the 2025 increase. I then took that total and increased it by 3.55%, which is the average increase in payroll for 2026. That number total was the difference between myself and the company. And so it's a really straightforward calculation, and I've yet to get any explanation why that's an inadequate calculation. It literally takes labor and annualizes it all the way through 2026. One of the reconciling differences is, it's my understanding Ms. Robbins used 4.5%. That doesn't, if you look at page 15 of my direct testimony, 4.5% is never listed as any average increase in the payroll. So that's one of the differences that we know of. The other one could be that the company has put in more employees, but that was never identified. We have no way, or there's been no reconciliation done between the level I proposed, which included 25 and 26 payroll increases, and the level that Ms. Robbins proposed. If you look at the difference in 2025 actual to what Ms. Robbins proposed for annualized payroll, it's about I had it in my testimony here. 16% increase.
Which testimony is that? Your direct or was that?
My direct, page 15.
Page 15.
Yeah. 16% is great, much greater than 4 and 3.5. And I yet to get a reconciliation of why that difference exists. My calculation, we both start at the same number for 2025. My calculation is very straightforward. I probably would disagree with the characterization that it's simplistic, but the arguments that have been provided by the company, is that they relied on an employee by employee analysis, and I would expect if we had that much of a difference that there'd be a way to reconcile those differences, and that hasn't been provided.
Thank you. I think that's all I have, Chairman.
Thank you. Ms. Anderson? Anything? I think make sure I've got everybody ask questions. I have no questions. You may stand down.
Thank you.
Mr. Lewis? You're doing stellar. Keep it up.
We'll call the AG's office will call Michael Dupree.
Thank you. Michael Dupree. Pull that mic up to you when you get a minute.
Okay.
There you go. Proceed.
Mr. Dupree, can you please state your full name for the record?
Yes, it's Michael W. Dupree. That's Deupree.
And where do you work?
I work at a Cadian Consulting Group.
And what position do you hold there?
I'm a senior research consultant.
Okay. And in your capacity there, did you file direct, surrebuttal, and opposition testimony in this docket?
I did.
Did you also file exhibits with each one of those documents?
There was no exhibits associated with my testimony in opposition to the settlement, but the associated with my direct and my surrebuttal testimony, there were exhibits. Yes.
Okay. Do you have any edits to any of your testimony or exhibits?
Yes, just two minor edits to my surrebuttal testimony. On page 6, footnote 7, it references direct testimony of Ronald J. Amon. That should be a reference to his rebuttal testimony, not his direct testimony. And on page 7 of my surrebuttal, footnote 14, the same correction. It references direct testimony of Ronald J. Amon. That should have referenced his rebuttal testimony.
I will pass the witness.
Thank you, sir. Mitchell?
No questions at this
No
time, Your Honor.
questions? Wesley, you have questions? Proceed.
Mr. Dupree, thank you for being here.
You're welcome.
Look at them. Look at them. I have a few questions for you today. Let's start here. Your testimony recommends against minimum size mains. Is that correct?
I recommend my recommendation is opposes the application of a minimum system study analysis in the allocation of distribution mains. Correct.
Is that a yes then?
I believe that's a yes to your question.
Okay.
Yes.
And you prefer, if I'm saying this right, you prefer the average and peak load methodology for distribution mains. Is that correct?
Yes. So importantly, there's two aspects of my recommendation associated with the allocation of distribution mains, and this is an important aspect of the cost allocation when we're talking about a gas utility, because the distribution mains is a very significant portion of the.
I just asked a straightforward question.
Right. Well, so
Instead of minimum size mains, you prefer the average and peak load approach.
But
Is that right?
there's two aspects to that. I first do not support the application of a minimum system study analysis to assign a portion of the cost allocation of distribution mains as a customer function. I secondly recommend that the cost allocation recognize a volumetric component to the allocation of distribution mains in recognition of both not only peak day usage but also off peak usage.
Using
especially
what methodology?
the peak and average? Yes.
Thank you. So are you familiar with Arkansas Act 725 of 2015?
Yes, I am.
And that is called the Arkansas Public Utility Regulatory Reform Act?
That sounds correct. Yes.
Let's call it Act 725.
Right.
So would you turn to page 21 of your direct?
You said page 21?
Yes.
Okay.
All right. Would you read line 24 on this page through line 5 on the next page?
To develop a cost allocation method under this section for natural gas utilities, the commission shall use the Gas Distribution Rate Design Manual, June 1989 edition, as published by the National Association of Regulatory Utility Commissioners, as existed on January 1st, 2015, or any subsequent version of the manual to the extent it produces an equivalent result. I might preference that this is
Nope,
that
just
this
keep
is
reading if you don't
after.
mind.
Oh.
Thanks.
The customer-related natural gas distribution plant costs shall be allocated to each customer class based on the number of customers in each class. Do you still want me to continue?
That's all I need from you. Thank you.
Okay.
Are you familiar with staff witness Spadoni's testimony?
Generally,
Okay. Did Mr. Spadoni's testimony apply your AMP methodology to the cost of service model in his rebuttal?
no, he did not.
So he didn't do that at page 4 to 6 of his rebuttal?
I mean, I'm not aware of it. If you can show me something different.
So you are familiar with his testimony, though?
Generally, yes.
Okay. Well, he did.
Okay.
And he showed a comparison on page 6 of his testimony, where he showed that applying the alternate distribution mains, where adopting your proposal would result in a substantial reallocation of cost responsibility from the residential class to the company's non-residential customer class. Are you familiar with that part?
Yes.
Okay. And are you familiar with the number that represents? Like how much would be reallocated from the customer class or from the residential class?
I mean, I don't recall that at this exact moment. I don't disagree with the fact that it would result
It's 15.2 million.
15.2 million. And I wouldn't disagree with the fact that there would be a significant change because, as I was just explaining, when we're talking about a
Thank
gas
you.
utility,
My
the
next question
distribution
is,
mains is a significant portion of the plant service.
does your testimony include analysis showing whether Arkansas businesses could absorb this rate impact and what that would do to our state's economy?
As I noted within my testimony, there is no testimony among any parties about the impacts on economic development within the state or,
I'm sorry.
or
Does
economics
your
in general.
does your testimony include analysis showing whether Arkansas businesses could absorb this impact and what that would do to our state's economy?
Yeah, it does not. It all,
Thank you.
I say that no party has shown what the economic impact of the increased rates to
My next
residential
question
customers would be
is-
either.
What did you eat for lunch?
I had a Caesar wrap.
Caesar wrap. Where'd
Yeah.
you get it?
Oh, I don't know the place. It's a down the street.
Restaurant.
Yeah.
How much of your bill did they make you pay?
Well, obviously, I paid for all of it.
Okay. Did you testify that revenue allocation is a zero-sum game?
Yes, it is.
Okay. In your settlement opposition, table 2,
Okay.
you recommend increasing small business by 15.85%. Is that correct?
Correct.
Um,
That's importantly. This is at the
It's a
settlement
yes or
revenue
no question.
requirement increase.
The original company's proposal would have increased by 80%. Is that correct?
Uh, okay, so what was that number again?
The original's company proposal, and this is a rough estimate, would have increased that number by about 80%. Is that right?
Would have increased the revenue?
The small
revenues?
business customer charge.
Oh, the customer charge.
Sorry if I
But
missed
and that's not, I mean, that's not presented in table 2. Yes, that is my understanding was that,
Okay.
yeah.
Did you testify that the current charge recovers 88% of the baseline cost to serve the small business class?
Yes, that sounds familiar.
Only 88%.
Yes, but I mean, it should be recognized there, you know, if there's plenty of businesses that have a fixed structure, you know, a fixed cost structure. I mean, take like a retail gasoline station that bear the volumetric risk associated with sales, right? There's not a pull up charge when you go to gas up your car, and it's just
Okay.
like utility service. There's no requirement that, you know, the customer charge needs to recover 100% of customer related costs.
But the
And as I
restaurant did
stated-
at lunch, right?
I mean,
This is badgering the witness. What's the stuff about the restaurant at lunch?
We're
I'm
just
going to allow it. It's cross-examination and it's a hostile witness.
all right.
thank you. Well, so
The point I'm making
but I
is
mean,
you had to pay
the-
for all of
so-
your lunch, but
I had to pay for all my lunch, just like
They're not allowed
customers
to
have to
recover
pay
all their
for all of their
costs.
utility bill,
okay.
right? I mean, what we're talking about is the separation between the customer charge and volumetric charge, right? And what I'm trying to say is that though it is a recognized element of rate design that fixed charges to fixed costs. That is not the only consideration that the commission should recognize when they're designing rates.
If I can
And
go
there
ahead
is
and wiggle
no
in here.
requirement that the fixed charge must
The
recover.
next
all
question
fixed
is, are you
retail
aware
costs.
that the settlement charge would cover only 90% of the baseline cost to serve the small business class?
That sounds accurate? Yeah.
Okay. Moving on. So, under the proposed settlement, small business rates will increase by 6.2 million. Is that right? I believe that's on your opposition, page 4.
I'm sorry. Could you repeat that question?
Page 4.
Yes, I'm there.
I think it's in table 1. Under the proposed settlement, small business rates will increase by 6.2 million.
Correct.
Okay. Are you aware that the company's application requested a $6 million increase to the small business class?
Yes, and that's presented in my testimony as a problem with the settlement because we're seeing a settlement that's actually going to be increasing rates more for small business customers than what was proposed by the company in their original filing.
In this zero-sum game, to quote you, a customer charge increase would force higher volumetric rates. Is that right?
Correct.
And so if I can quote you again, robbing Peter to pay Paul does not promote economic development or employment opportunities in the state. Is that a quote of yours?
That is a quote of mine, but
Thank you very much. No further questions, Your Honor.
Redirect?
Yes.
Yes, sir. Calm your hostile witness down.
Yeah.
I'm kidding, of course.
You were
I'll
just
calm down. Sorry.
you were just asked a question about robbing Peter to pay Paul. Please explain yourself.
Yes. So the question as designed conflates two issues that are within my testimony. One is about the customer charge versus the volumetric charge. The other issue is about revenue allocation between which class is assigned the revenue increase at the end of this case. And as I was mentioning in my testimony, Act 725 requires as a necessary condition for the commission to find that the use of the minimum system approach, right, and generally how the company and staff has allocated the distribution mains to result in economic growth in the state of Arkansas. And what I was saying is that the revenue allocation process is a zero-sum game. In order to decrease the rates for one set of customers, you have to increase the rates for another set of customers. And in this case, you're increasing rates for residential customers in order to decrease rates for the industrial and large business classes. And residential customers support the local economy by buying services, going to the grocery store, and supporting local businesses in that way. And so that's why I was saying that the notion that there is economic growth by robbing Peter to pay Paul is not appropriate on its face. And that's what I was getting at. That statement that I made in my testimony was not to do with the volumetric versus fixed charge. As I was trying to explain to the attorney, that's just an element of rate design. I don't agree with the company's approach with the customer charge, but that element was associated with the revenue allocation.
Thank you.
Thank you. Anything further of this witness? No questions? No questions? Any questions? Going once? Going twice? Mr. Tate, no questions? No questions. You may stand down.
Thank you.
Thank you. Anything further, Mr. Lewis? I think that's
it for us.
it. Anything further over here on the right, on the far right? That's it?
Nothing from us.
Let me talk a bit about where I see us going, okay? And y'all listen to where I see us going and tell me if you can follow that road, okay? It's my understanding we have till October 5th to enter an order in this matter. I anticipate that we will review the testimony today and determine whether to approve the settlement or not. If we determine that we are going to modify the order based on our questions or the position of the Attorney General, we will issue that order. And what I anticipate is if the settling parties do not agree with that order, they will have roughly 10 days to request a full rate hearing, which we will accommodate and have a hearing in plenty of time to where we can issue a new order before October 5th. Is that agreeable? Y'all understand we're trying to be fair to all parties, okay? And that gives you a chance. I don't think y'all need to, if you don't agree with the settling order, you've already had one shot at the apple anyway. Unless you don't agree with the settling order, or you could ask for a full hearing also, if you wish to. A full rate.
I'm happy with how
I phrased it.
Okay. Seems
very good.
Yeah.
Mr. Chisenhall, does that melt your butter?
Processing, Your Honor.
Okay. I understand. I will suggest these. Mr. Parks, think you process too.
I'm absolutely fine with.
Okay. Oh, I got 2 fines. I've got majority.
Not the first time I've been outvoted. I just want a little clarity here.
That's all right.
Okay, October the 5th is the drop dead date.
Yes.
So y'all are going to take this, ponder it, consider, either affirm or modify.
Yes.
And that order will come. That's the part I'm not specific.
Well, it will come sufficiently so that we can have sufficient time to have a hearing, a full rate case hearing, and issue an order by October the 5th.
So
that means we're moving forward very quickly.
So we could expect an order mid-September?
Surely we can do that before then.
Chairman, may
Yes.
I add something?
Yes.
I think the process you've laid out makes sense. I know this issue has come up before. The commission has three options as I see it with the settlement agreement, right? Accept, modify, or reject. If we reject it, we go to a full hearing. If we modify it and the settling parties don't agree to it, then we go to a full hearing. If that's the case, we could have a hearing as soon as we know, whether we have rejected it or the parties reject our modifications. I don't know that we'll have an order out by that October 5th date if that is the case.
Well,
And I think that was contemplated in previous dockets where this issue has come up. In fact, I think in those dockets, an order from the commission saying, here's the modifications, parties do you accept, came only a couple days before that drop dead order date. Now, we would have to look at the statutes to determine what rate would go into effect on a temporary basis until that final order came out. I don't know that it's the applicant's application rate. It might be that modified rate, but we'll cross that bridge, I think, if we have to. Does that make sense, Mr. Chisenhall?
Commissioner, it makes sense, but having been through maybe one situation similar to that, putting rates into effect under bond is a nightmare I don't think any of us really desire.
I think that's a situation we would all like to avoid. But we'll see what happens with the proposed settlement.
And I think the idea is to ensure or make sure the parties know that we will do our very best to move it along as quickly as possible too. It's going to be a game of cooperation and getting it done. But I think what the chairman's trying to say is that we will do what we can to have something done by the 5th or as soon as possible.
Yeah,
And we have precedent. We're basing this on precedent to do it. Now, let me say this. It'll be easy peasy if you don't request a full rate hearing. Okay? We'll be done long before October 5th. Okay? So, anyways, at least we know the ground rules at this point if y'all are comfortable.
There are some complications with that. Part of it is what Commissioner Tate described. It frankly be a mess to put one rate in and then do something else a few weeks later.
Well, you'd be amazed what we can do. Okay?
Yep.
In orders, our order could state that option as
Right.
well. Okay?
And other complication is scheduling witnesses. We have 9, some of which
I think you would have to consider that if you decide to elect a full rate case.
Right. Normal procedure would be commission issues an order. We have 30 days to request a petition for rehearing. Other side has 10 days to respond. Then we have you rule 30 days to request an appeal. So we're kind of getting short change on procedures with that. So
I understand your point, Mr. Danjo, but I think the RPP specifically contemplate this settlement process, right? Which is a shortened deadline for the parties to decide to accept or reject a modification settlement.
right.
The alternative would be in the future, we would have to move up settlement deadlines quite a bit, which means shortened deadlines for rounds of testimony if we were going to have a process where the settlement deadline is done sufficiently in advance for a settlement hearing and for the commission to have time to consider it, issue an order, and then still have time for the full litigated process if that doesn't work out.
Right. Well, if that's what the commission wants to do, we'll go with it. But I would object to getting forced into a situation where we have no viable option other than to accept your modification, which
we're trying to be
real
benevolent.
close to that.
We're trying to be benevolent. The other thing we could do is issue an order based on this,
Yeah.
and you could decide a request for a rehearing at that point, not give you the option to request a full hearing. We can shorten the time frame, but we're trying to be benevolent and give you that option if we modify the agreement.
Right.
Okay?
Well, we'll
There's a lot of unknowns at this point.
there is, yeah.
Okay.
We'll give it a shot, and we have irreconcilable problems. We'll work with you on
We
it.
appreciate your
Yeah.
thoughts, and we will consider all of those things. So, any questions? Any further questions? We're going to leave we're going to recess this that way. If we do have a additional hearing, we won't have to go through the ceremonies of this, so that we can do it quicker. Okay. So the testimony concerning and the hearing concerning the settlement agreement is adjourned, but the record and the hearing is left in recess for possible future hearing. Okay? So ordered. Thank you. Thank you all. You may be seated. Okay?